Good morning, everyone, and welcome to On the Line with AgriLife. It is 8:30, and so we'll get started here as we go through this morning's program. So really quickly, we want to introduce you to the On the Line with AgriLife program. This is a quick program that we hope that you enjoy that's supposed to be about 15 to 20 minute update on a relevant issue, and then followed by a question and answer sessions where you can ask questions to either our agents or our specialist like Ms. Lashmit that's joining us today.
Good morning, everyone. I just wanted to quickly talk about our Remind text message group. Through Remind, we send out reminders about our upcoming On the Line with AgriLife programs and surveys. We promise to not bombard your phone with messages. To join, text at OTLWA to 81010. That's at OTLWA, the initial letter of each word, and On the Line with AgriLife to 81010. We hope you join our Remind group and enjoy the program this morning.
Thank you, Jessica. All right, I want to give everyone the opportunity to register and sign up to receive our Connecting West Texas Farmers and Ranchers newsletter. And this is the newsletter that is a comprehensive over a variety of agricultural topics. So we usually have sheep and goats, cattle, pasture management, range management, cotton, anything and everything and anything in between. You can sign up to receive that at valverde.agrilife.org/connecting West Texas Farmers and Ranchers with Extension website. The same place you went to get today's link. Our next On the Line with AgriLife will be January 19th, 2021 at 8:30 a.m. Again, we'll have Dr. Calvin Trossel joining us to discuss alternative crop options in West Texas. So thanks for everyone for joining us. Let me kind of switch over here. And let's welcome Miss Tiffany Lashmit. She is our Ag Law specialist. She's located out in Amarillo where it's very cold. Lucky her. One thing I was thinking about Tiffany today was it's 30 degrees here and I'm freezing. And I don't know what it is there, but you're freezing.
That's right. Apparently it's just freezing all over Texas.
So tell us a little bit about yourself and the job you do with Extension.
Sure. Yeah. Thanks for having me, Emily. I'm an Extension Ag Law specialist. Like Emily said, I'm based in our Research and Extension Center in Amarillo, but I have statewide responsibilities. So I cover the entire state, providing agricultural law information to folks. So educational information on anything that relates to ag law. And I really try to focus on issues that affect Texas rural landowners and ag producers. So everything from like water law to estate planning, fence law to landowner liability. Those are kind of the areas that I work in. I grew up on a family farm and ranch in New Mexico. My family raises cattle and sheep and has both irrigated and dryland cropland. My husband and I now live in the Panhandle. We've got some ranch land here and a couple of little ones that keep our hands plentiful.
Well, it is always a joy to see what's going on with your family out there in West Texas. Definitely following you on your social media pages. So, Tiffany, I know you have some great resources, and before we dive into these 3 key cases from 2020, would you kind of share the resources that you have and that people, and I'll go ahead and post that link in the chat box for anyone who wants to find those.
Perfect. Yeah, and if you, I'm going to give you kind of 4 different things, and I'm just kind of pick 4 to highlight. The first is our Texas Agriculture Law blog. It's just a website where we post information on agricultural law. So if a new case comes out, I'm going to do a blog post on that. If I do a checklist or a handbook or anything like that, it all gets posted there. And I've got these links, Emily, if you want me to, I've already got them pulled. So I'll just put them in there. We may have them doubled, but that's all right. And so the blog, like I said, when you go, you're going to get a pop-up box. And I know that those are annoying. But if you put your email address in there, what will happen is you'll subscribe and all my posts will go directly to you anytime they get posted. So it's basically just an email from me. So that's the blog. And I think it's a useful resource if you're interested in this topic. The second thing I'll mention is my Ag Law in the Field podcast. And so if you're a podcast listener, just search for Ag Law in the Fields, anywhere you listen to your podcasts. If you're not a podcast listener and you'd like to check it out, it's essentially just an audio-only interview between me and another ag lawyer for each episode. And you can go to our website. We've got the link in the chat box there. What you'll find when you get there is literally a list of like 94 episodes that we've done. And so as you can imagine, in 94 episodes, we've covered the gamut of kind of any topic you could think of. And I've been really fortunate to have some of the best ag lawyers in the country come on and talk to us. So it's free to listen to. I think it's a really good resource for folks to have. Two other specific resources that I want to mention. The first is my Owning Your Piece of Texas handbook. And I wrote this handbook specifically for, again, Texas ag producers and rural landowners, just to give them kind of an overview of the different legal issues that they could face as being a landowner and being involved in production agriculture. So there's like 13 chapters. It's just an overview of each issue. I really did my best to write it kind of for a lay audience. Emily, you know my dad, but my goal is always, if my dad could understand it, it's probably fine.
It's very true.
And then the last link I have is a link to our online ranchers leasing workshop. That's just an online course where we really focus on grazing, hunting, and livestock leases. What should be in them? How much should we be charging? How do we protect ourselves from liability? It's about a 3-hour class, and we've got a link for that as well.
Well, thank you. I always do chuckle thinking about your family and all their fun. So
it provides some good examples for some of the presentations that I do.
I'm sure. So let's dive into these 3 cases from 2020. So first, let's talk about Pruski versus Garcia. This was a fence law case in Wilson County that definitely highlights why it's so important to understand fence laws. So kind of give us the background and that case and why that's one of your 3 key cases.
Yeah, for sure. Well, I'll tell you, people were really interested in this case. And when I pulled the data about, the most popular blog posts, this one was like by far the most listened to. I mean, the most read, almost double every other post. So people were really interested in it. And again, I think it's because there's a lot about fence law we maybe don't really understand. And what happened here is something that could happen to any of us. A cattle owner had a bull get out. He was hit by a vehicle on a state highway, and the owner found himself facing a lawsuit, right? So the driver sues the owner for negligence for the bull being on the highway. And so the question initially for any fence law case is going to be, is this an open range area or a closed range area, right? And the general rule in Texas is we're open range unless there's been a law that changes us from open to closed. And in a lot of places, there are those laws. Here's where the case got tricky, is there were 2 of those laws that could apply in this scenario. So what we had is the bull was hit on a state highway. And there's a statewide statute that says any U.S. or state highway in Texas is closed range. And what the statute says is a bull owner or a livestock owner can be liable only if they knowingly permit the animal to run at large on the state highway. The second statute that applied is actually a local stock law for Wilson County, and it says that for the entire county, a livestock owner can be liable if they permit the animal to run at large. So in this case, we knew it was closed range, but we didn't know which standard would apply, right? Knowingly permit is what the bull owner wanted because that's harder to prove. And permit is what the driver of the car wanted. It's easier for him to show that. And the court had never ruled on what happens when we're in a situation where there's kind of a double closed range. And the Texas Supreme Court ended up saying that it's only that higher standard that applies. So in other words, the bull owner wins. And if there is a collision on a state or U.S. highway in a county with a stock law, it's going to only be that higher knowingly permit standard that applies. And that's an issue. I mean, this could affect landowners probably in most counties across Texas. This could be a situation.
Absolutely. So I've got several questions to kind of piggyback off of that one. So open versus closed range. You talked about most of us in Texas are open unless there's been made a law. How do we find that information? Where is
Yeah,
it?
and I actually think most of Texas is probably closed, but where it's tricky is the default is open range. So you've got to go find out, is there a local stock law in my county? And
Wait. Before you go on, what is a stock law?
Okay, a stock law
Where are those?
Well, this is where it gets tricky. A stock law is going to be, there will be an election held in the county where the landowners vote and decide to change the county from open range to closed range. You'll find the results in the commissioner court records. Where it gets tricky is that a lot of those were passed back in the early 1900s, and it can be tough to dig back and find them. So here's what I always tell people. I'm going to give you a list of folks to start with. Ask your county agent, ask your county judge, county attorney, county sheriff. Our hope is that one of them has dealt with it before and can help give you the answer easily. If not, you need to contact the county clerk, and you'll have to search through those commissioner court minutes to see if an election was ever held. I'll tell you, Emily, and I mean, I think you know this, but I'm working on trying to compile all the stock laws in Texas with the hope of having a website one day where people can just click on their county and pull it up. We're working on it, but we're not there yet.
Wow, that sounds like lots of fun commissioner court diving experiences. I will say, thankfully, I do know Valverde County is open range, but like you said, the state highways, everyone who has land along that state highway is closed range already. So that's, I'm glad I know, so I do not have to go through 1900 commissioner court reports. So
For sure.
So the next case that you are going to share about that's important in 2020 for our landowners is as they navigate easements on their property. This kind of impacts us all. Tell us a little bit about this one. I think this one's very interesting. I hope family members of mine are listening.
Yeah, as far as cases that are going to impact a lot of people, this is probably the one for the year. This case also came out of the Texas Supreme Court. It's called Southwestern Electric Power Company versus Lynch. And what happened here is a situation many of us have where there was an old blanket easement on Mr. Lynch's property from back in like 1949. And in the 40s, it was a transmission line easement. His predecessor owner signed it. There was no width limitation. Okay, so it just said, they got the right to put in a transmission line, no details. And so they paid for it. They put in the transmission line. And for years, the company used a 30-foot wide easement on which that line was located. When 2014, the company came in and wanted to modernize the line. So they were going to go in and replace the wooden poles with steel poles, et cetera. And they came to Mr. Lynch, who now owns the property, and said, hey, we're going to offer you $1,000, but we want you to amend the easement to say it's 100-foot wide. And Mr. Lynch said, no, I don't think so. You've only ever used 30 foot. So even though the easement is silent, I think it should be limited to 30 feet. And so they go back and forth, the company basically saying there is no limit, Mr. Lynch saying it's the historic use. Both the trial court and the appellate court sided with Mr. Lynch and limited the width, but the Texas Supreme Court reversed. And they came in and said, listen, if the parties don't specify a width in an easement, we're not going to write that term in. Essentially, if you want that term, you better write it in, because we're not going to impose a limitation you didn't negotiate for.
Well, that will impact quite a few landowners across the state, I guess. So as that impacts a lot of landowners that are out there with current blanket easements, is there anything that we can do at this point? Can we put the genie back in the bottle? Do you recommend that they get in touch with their attorney and see about going ahead and negotiating those with the easements? What do we do other than moving forward, make sure we're very specific as we navigate those easements?
Yeah, I think the biggest takeaway from this case is if you're going to negotiate an easement, you have to spell out the details. We never want to negotiate a blanket easement. And a lot of times the easement form that's given to you by the company, right, that was written by their lawyer on their behalf is going to be a blanket. And so going forward, the best thing you can do, I really recommend before you sign an easement, have an attorney help you with the drafting and making sure you've got those kind of details in there. For those of us who the ship already sailed, right? Like we've got easements from the 40s that are blanket. What do we do? There's probably not a lot you can do, truthfully. One thing I always tell people is if the company comes in and wants something from you, then you've got some leverage to try to negotiate limitations that aren't already in the existing easement. So if the company comes in and wants, another easement, or they need to, cross you to get to another place or something, if you get a situation where you've got some leverage, that's where it might be worth trying to negotiate some new limitations in those old blanket easements. It probably is not worth, in most cases, going through and finding all the blanket easements that exist on your property and picking up the phone to call them today.
Gotcha. Good advice. Okay, so let's tackle this last important key case from 2020. The Walk versus, I'm not even going to try to pronounce it, that deals with the landowner being sued by a ranch employee's family for negligence as a result of an animal accident. Isn't all that covered?
Yeah, this case was real tragic, and it happened in a ranch in Central Texas where the employee was working and he was killed while he was moving a bull for the landowner. And so his family filed a lawsuit against the landowner. Rancher didn't have workers' comp insurance for his employees. That would have kind of handled the problem. He didn't have that. So we have a negligence lawsuit, and the ranch owner, to I think your point, Emily, says, wait a minute, the Farm Animal Liability Act applies, right? And that act basically is a defense for a livestock owner if someone is injured or killed during a farm animal activity. And moving a bull sure looks like a farm animal activity. The trial court agreed and dismissed the case. The appellate court, we won't get into that decision because it really doesn't matter now. They end up at the Texas Supreme Court, and the Supreme Court issued what I thought was a really surprising decision. And they said that the Texas Farm Animal Liability Act does not apply if the injured party is a rancher or a ranch hand. Essentially, they said, we think the purpose of this statute was really to apply to things like shows and rodeos and trail rides and riding lessons. We don't think it was meant to apply to kind of a working ranch scenario. And so that was surprising. I think a lot of us were really shocked. There was a strong dissent in the case. Two justices basically said, you're rewriting the law. Nothing in the text says that, and it's not our job to rewrite the law. So that case was pretty shocking, certainly something for livestock and horse owners to be aware of, a severe limitation on the applicability of that defense. I will say I'd watch for this case in the legislature this year. It wouldn't surprise me to see an amendment to that act be proposed by some of the ag groups in response to this case to make clear that the legislature does intend it to apply to ranches. We'll see if that pans out. Well,
in talking about that, if it doesn't pan out in the legislature this next session, what is your recommendation? I know what it is, but I'm going to ask anyways. What is your go-to recommendations for landowners to protect themselves? Go now. Speak. Preach.
Yeah, there's a number of things you can do. By far, the most important is to have liability insurance. It's something that's easy to overlook, but it's really critical. If you own property or if you are leasing property, you need to make sure you have liability insurance on that land. And make sure it does two things. Covers every activity you have going on, right? So if you've got paid hunters, you better make sure that's covered. And make sure it covers all your properties. So, for example, we leased a new place for our cows not too long ago, and before our cows set foot on that place, I made sure our insurance coverage was in place. Okay, and the benefit of liability insurance is really twofold. First, it obviously provides you money for a settlement or a judgment up to your policy limits, but it also provides you a defense in the case you get sued. What that means is if somebody gets injured at my place, my first phone call is to my insurance company, right? They hire me a lawyer on their dime to get me out of the case. So, there are other things you can do for certain activities on the property. Far and away, the most important thing that every landowner needs to have is liability insurance.
Well, I think it's fun. I thought it's your go-to statement, and you're very passionate about that one.
Yeah.
And I think it's a great advancement. So those of you who called in today, we will post all of the links that Tiffany has provided us on our website. If you called in, we'll make sure they're there for you to go back and find. But does anybody have any questions today? You feel free to unmute your mic or type that in the chat box, and we will get those questions answered. All right. Tiffany, while we wait for questions to come in, do you have anything else to kind of wrap up or in 2020 on?
Say that again.
Or do you have anything to wrap up or in 2020 on?
Yeah, I mean, like I say, there's so many ag law issues out there. It's a really fun area. It's a fun job for me. I would just say, if you're interested in the topic, checking out the blog is probably the best thing you can do. That'll keep you up to date. Like, there's posts on all these cases. We've talked about things going on nationwide, like the definition of waters of the U.S., et cetera. So if that's a topic you're interested in, we'd love to have you check out the blog and the podcast.
Wonderful. So we do have our first question there. Got $1 million umbrella policy for a 70-acre cow-calf operation. Is that enough?
Well, lawyer you. I think that's Roland. I'm going to lawyer you and tell you it depends. Okay. So a couple of things. The first thing is, an umbrella policy is great, but I want to make sure we understand what that means. And I'm sure you do, but just in case anybody else doesn't. Okay. So an umbrella policy, sometimes people will say to me, I don't have to worry. I have an umbrella and that covers everything. Keep in mind that to get an umbrella, you first have to have a base liability policy. And that base policy describes the scope of the coverage, right? So like, is hunting covered or not? The base describes that. What the umbrella does is sit on top of that base and increase the dollar amount of coverage. So here, the umbrella gives you $1 million in coverage, like a top hat, right? It goes up. It doesn't cover more things. So first thing, make sure that all of your activities are covered. Then the reason it depends, it really depends on your operation. Look, in general, I think $1 million liability policy is really good. Now, if your place is located right next to an interstate and you have cows that jump and you have a ton of hunters that come out and you, I don't know, also like host birding events and you've got bird people and hunters at the same time, things are looking more dangerous to me, right? Than our place where we've just got our cows out in the pasture and nobody ever goes out there. So that's where you've got to analyze, is that enough coverage or not? In general, I certainly think $1 million type liability policy is good for most kind of quote unquote normal ranch operations. But again, I talk with your agent, really look at exactly what you're doing.
Throwing my birding programs under the bus, aren't we, Tiffany? Huh?
I know.
But it's okay. Anybody else out there have questions? I know we have some on the phone. If you would like to unmute or and ask any questions, you're more than welcome to. Let it trickle in. I don't see anyone unmuting, but we want to thank everyone so much for joining in, and don't forget to join us on January 19th as we talk about alternative crops in West Texas with Dr. Calvin Trossel. And again, 8:30, you can find the call-in number or the link to access the Zoom on our website. So thank you, Tiffany, so much for joining us from way South Texas and Mexico, almost up to the Texas Panhandle. It's kind of fun how Zoom can connect us all. So
Absolutely. Thank you for having me, Emily.
Absolutely. Thank you, everyone, for joining in, and we hope you'll have a good rest of the year in 2020, and we'll start fresh in 2021.